be speaking with me, Tarun Nangia. NCLAT Chairman Justice Ashok Bhushan has stayed insolvency proceedings against HCL Tech, a globally renowned company, in a matter which involved payment of dues to a travel operator. What was this case all about and why it caught the headlines? It involves a big, highly profit-making company which has lakhs of shareholders known to all of us. That's why we discuss this issue tonight. May I welcome my panel today. Advocate Samir Jain joins us. He argued on behalf of HCL and got the honor. Congratulations, Samir. I have with me Shashank Garg. Advocate Shashank Garg joins us. Tahira Karanjawala from Karanjawala and Company joins us. I have with me Advocate Ishna Kumar and also Shashank Garg. Shravan Shankar. Advocate Shravan Shankar joins us. First, let me request Samir Jain to lay the ground before we move ahead and discuss this order by the NCLAT. Samir, in about 2 minutes, could you explain the issue before we move ahead?
Sure. I mean, I'll try to be as non-controversial as possible, but it's simply from the legal standpoint, the issue is that what's the scope of NCLT's jurisdiction, whether it can go into disputed questions of fact, when there's a pending dispute between the parties, should NCLT enter into a domain of contractual interpretation and then determine whether a party is liable or not, or is it a forum where only admitted debts, so to say, are considered within the scope of Section 9? That's the long and short of this case. I would not really be in a position to discuss the factual merits of the case, but that's not really important here. So that's the long and short of the matter. And our case before the NCLAT is not on the merits of the dispute. Our basically case is very simple. It's what's the scope of NCLT's jurisdiction under IBC.
So for my viewers' benefit, let me share that this case involved the petitioner, which was a travel operator, said that HCL had to pay them, that company, the tour operator, about 3.5 crores, 3.5 crores, which were not paid. And hence it moved this application to NCLT, where they got an order in their favor, which was stayed by NCLT. I'll go to Advocate Shashank Garg to take forward this issue and for his comments on this.
Tarun, like Samir said, and you've already stated what were the basic facts of the case. One has to see what is the objective of IBC, what is the objective by which these proceedings under Section 9 or the notice under 8 are to be sent, and how NCLT and NCLAT are dealing with it. Now, again, not with respect to the specifics of the case, what we have to really see is, are we looking at a company which is likely to go into liquidation? Are we looking at a company which does not have resources and assets to cover up a debt of 3.5 crores? The answer is no. We're looking at a company which has made over 8,500 crore profit last year, which has 2 lakh employees. The share market, of course, you've touched that aspect, gets impacted when you touch companies like these. So whenever a court is dealing with a Section 9, proceedings under IBC, the allegations have to be evaluated along with the set of facts and, the relevant factors involving whose reputation is at stake, what will be the impact of such an order. And in this particular case, from what I read from NCLT and NCLAT's judgment, it was clear that there was a pre-existing dispute, which was evident from the email exchange. Now, to discredit that, is that really in the jurisdiction of NCLT? Because the ingredient or the requirement is of a pre-existing dispute. The merit of that is to be adjudicated by the right forum, which, in my opinion, is not NCLT.
Point well taken, Shashank. I'll take this to Tahira Karanjawala. Now, you have a wide experience by your law firm appearing in such matters. What are the learnings from such orders that are for the industry and the law firms and the lawyers? Because it also involves forum shopping in that sense. How would you look at this?
Thank you, Tarun. So, in fact, I think this is a perfect example of how a case which really reflects the rigors of the IBC process, where a company like HCL Technology share capital of 542 crores has been made the subject matter of an insolvency petition. Nobody, as Shashank was saying, that nobody really thinks this company is in a precarious financial position. But this is the IBC code as we see it. Here, the scope of the adjudicating authority is very limited. They basically have to see whether there is a debt and admitted debt. Now, in this case, the problem is that the NCLT has admitted an insolvency petition on an application of an operational creditor for a debt of 3.5 crores, where clearly there was a pre-existing dispute which had been raised. Now, all the Supreme Court has laid down the law that all that the NCLT has to see in this particular situation is whether there is a plausible contention raised by the corporate debtor. It cannot get into, and this is what has been observed by the NCLAT when it stays the judgment, it cannot act like a civil court and start getting into the contractual interpretation. So in this particular case, the NCLT does a deep analysis of the correspondence of the addendums to the agreement under which the operational debtor was claiming, and then dismisses the defense of the corporate debtor as a moonshine defense, and hence admits the insolvency petition, which has far-reaching consequences, of course, for the company. So I think the NCLAT very swiftly within a day stays this, saying that there was a genuine pre-existing dispute which was brought to the attention of the learned NCLT, and therefore this petition ought not to have been admitted at that stage. So I think one of the things that the things that the legal community and the industry generally takes away from this case is that one cannot underestimate how an IBC proceeding. It can be a small cab operator or anything, but it has to be taken very seriously, because the scope in which the adjudicating authority operates is a very strict scope. So therefore, in this case, there was a genuine pre-existing dispute. But often, if you have not disputed the claim and there is a claim of over 1 lakh, then the adjudicating authority unfortunately has no option but to admit the case for insolvency. So I think that's what we take away, that one cannot underestimate how rigorous the IBC proceedings can be.
Tahira, this brings me to the question that I'm going to ask both Shravant and Ishna and then take to the panel. In this case, maybe Samir got lucky, the case was listed in a day, heard, and he got the relief. The pendency in NCLAT is growing. The NCLT pendency also unexpectedly has grown too much. We can attribute it to the pandemic also. What happens if you are not able to get a hearing in a day's time? The stock markets can crash by thousands of crores of rupees, and money is not recovered easily. The markets then don't come back easily. Shravan, do you think that the impact is very far-reaching, and only because in this case you got a relief early, we couldn't see the worst of it?
Oh, yes, I can't agree more, Tarun. Especially for public listed companies, the impact is far-reaching for not just the actual, to all the shareholders publicly holding shares of the company. Because see, essentially, if you look at the impact, so if you see, in fact, Supreme Court has also held that IRP cannot be appointed to prematurely initiate insolvency process, or it cannot be done for extraneous circumstances. Here, the issues were very simple. There was a pre-existing dispute, and there was also an issue of limitation. However, the NCLAT, in their stay order, do not go into the issues of limitation. They go into the issue of existence of pre-existing dispute. Now, as clearly stated in Mobilox much earlier by the Supreme Court, the pre-existing dispute, it should not be subsequent to the Section 8 demand, but it has to be earlier. And very clearly, the correspondence is very clear in this case. However, the adjudicating authority went into far lengths to determine like a fact-finding court, and perhaps if they have any other claim in any other forum, their claims could have been prejudiced. So, rightly so, they have a great impact, especially on publicly listed companies.
Okay, point well taken. Ishna Kumar, your answer on the question.
Thanks. So I think if I relate it to the pendency of the matters that are there in NCLT, I think the answer to that would be with regard to the ambit of what the adjudicating authority has to look into. And I think the approach of the adjudicating authority in an insolvency regime is very limited to look at it's a summary proceeding where we are not here looking at a recovery, and that is why the test, as there is which we've taken from the UK Insolvency Bankruptcy Code, is that if a corporate cannot pay a lakh of rupees or there it's 10,000 pounds, then of course in that case it's a company which is insolvent. And that's why I think what happens is, especially in cases of operational creditors, is that if the company is solvent, it really and is escaping payment, then in that case it goes into settlement, like we've seen the OYO case, where OYO Hotels case, where eventually the entire dispute got settled because they were in a position to pay. However, where here, like in the case of HCL, where there is a genuine dispute, because what are we looking at? What is there an amount that's outstanding? Yeah, of course, that's what the allegation of the travel operator was, the cab operator, the travel agency was. But is that amount really outstanding? And that, of course, we are saying that that's not out. I mean, HCL is saying that that's not outstanding. And coming to the repercussions of it, like you say, Tarun, that once it's admitted, it becomes in what's known as an in rem proceeding. Till the time it's not admitted, it's an in personam, because what we know is between two parties. But as soon as it's admitted, the repercussions of it goes to the financial institutions. And here we are talking about a cash-rich, full liquidity company. 8,700 crore profit is a huge amount with so many shareholders. And you're absolutely right. I mean, getting hats off to Mr. Sameer to get this order within a period of 2 days. I mean, getting it listed with the stay, it's beautiful. But not, I mean, we're not lucky always. And after the IRP has taken over, it's only stay on the constitution of the COC, what we call, that is the constitution of the financial institutions. So I totally agree that, we are, I mean, we do face situations every day, but the pendency of the matters has a repercussion with regard to what extent the adjudicating authority is to interfere. And, the more they interfere in it, of course, more the time and more the pendency. So in my assessment, till the time the approach is objective, to the extent that, there is a dispute and therefore we do not have to look into this application, till that time it's fine. But as soon as the subjective testing starts, that's where I think the lengthy process starts, which the code actually intends to steer away from.
Okay, point well taken, Ishna. Now the learnings from this episode. It was a short episode, but with long learnings. Sameer, 2 points to be raised here. If a creditor has a dispute against the company and uses NCLT process as a weapon to extract and settle payments, because a big company will think that it is better to pay the amount and settle, even if they are right, rather than suffer losses in the share market and the shareholders and all the bad press that comes along with such orders. Do you think NCLT knowingly, unknowingly is being used as a weapon by certain motivated creditors, or do you think this is too much to infer from this order?
Well, I won't comment as to what was the intent here, but then most certainly NCLT is being used as a weapon for extracting the debt or supposed debt. A lot of matters get settled at the notice stage. A lot of matters probably will get settled if there's an order or anything. And this is a classic case because there is an arbitration agreement under the arbitration clause in the agreement, and it's they're not one, but I can say that much, that there on an identical dispute, there's an arbitration which was initiated. The full trial went on, and there was an award in favor of HCL on identical issues. So there's a fact-finding body which does a trial and determines there's no liability, and then there's with all due respect, there's the court which overreaches the jurisdiction and says, no, I will determine what the interpretation of the contract is, and that is the intent which should not be, and this is not something which the court should do, at least when they are dealing with legislations like IBC, which have serious consequences, Tahira said. So the learning is that, yes, you must be very careful when you're dealing with your client's matter, the IBC, and the learning goes both ways, I think. And the limited scope which the tribunal deals in is something which needs to be determined. Forum shopping, you use the word forum shopping, and that's quite an apt term in my view when we look at cases like this.
On this note, we'll take a short break, and we have Shashank on the other side of the break. We had Samir sharing with us the kind of pitfalls that the NCLT process has also fallen victim to by being misused by certain motivated creditors. I will go across to Shashank. Shashank, learnings from this episode, because it's just not about HCL Tech. It is also about many other cases where you may not get a listing in one day. You may get listing after 2 weeks, 3 weeks. By then, there would be a lot of damage to the company.
I think that's a very, very pertinent point, Tarun. In fact, you might be just giving away more strategic points to such, creditors, because then they will use the vacations. They will file these NCLT proceedings strategically so that people like Samir cannot move to NCLAT in time. But coming back to the question that you have raised, see, IBC in 2016 was brought in with a certain objective. The primary objective was reorganization, to rescue a company which is in financial trouble, to rationally distribute its assets amongst its operational and financial creditors. And that was the objective. So from rescuing a company, we are seeing that it is now being used to harass a company. And very commonly we say that, we often use economic offences wing, other mechanisms such as filing criminal cases, registering FIRs, changing the color of a civil proceeding into criminal proceeding. This was being used very often by parties who wanted a settlement, who wanted a forced settlement. Now this is coming out to be a more sophisticated tool. Of course, registering of FIR, etc., would require a very different ball game. But if you can use something as sophisticated as IBC and file a Section 9 and get a listed company in trouble, of course they will have to settle, because a 3-day, 4-day, 5-day window, a case like this where the dispute is about 3.5 crores, the loss that they would get in a week's time or a 4 or 5 day would be much higher. And loss of reputation, I think we cannot even measure, which would not be restored just by a stay order after a week or 20 days later when Supreme Court interferes in it, because public memory is short. Right. So I think there are grave consequences. And of course, this is a very, very important, legal field which is emerging. So everybody who's a stakeholder, from the side of the lawyers, the registry of NCLT, NCLT itself, everybody has to play a vital role in ensuring that IBC actually achieves its objective and is not really being abused or used as a tool.
Important last statement by Shashank. IBC achieving its objective and not being misused as a tool. Tahira, if you could look at it this way, when the IBC was framed, I think this wouldn't have been envisioned, or this misuse wouldn't have been anticipated. Do you think this is one learning that we get from this order, that this misuse can get rampant tomorrow? What is just happening now in bits and pieces? Could this be a problem? What we are learning, which could be much bigger tomorrow than today?
Yes, Tarun. Honestly, from the beginning, one of the things that the courts have repeatedly said is that the insolvency code should not be made a process for recovery of debts. That was never the intention. But it is natural, and sort of any creditor, because it is actually a very effective way of recovering your debts. You file such a petition, and then hopefully before it is admitted, the corporate debtor pays your debt, and then you are free to go. So this misuse is definitely there, but I think it has to be, and this is what the Parliament has also probably felt, that the positives of the IBC and having it stringent probably outweigh the negatives, and therefore, because otherwise you have a situation where huge amounts of outstanding debt remain on the books of companies, and therefore, it's a balance that has to be drawn. Perhaps in the future we will see, as the NCLAT perhaps may do in this case, that you have to construe it very strictly. Then it cannot, you cannot have a situation where disputed debts like this are allowed to throw companies into insolvency. So probably that interpretation will evolve, so that the misuse, as any laws evolves, to the courts evolve their judgments in a way which decreases the misuse of any law. I think we will see more of that in the years to come.
Okay. Shravan, coming to you, your learnings from this episode in this order.
So, but for eminent lawyers like Samir Jain and increasing the threshold from 1 lakh to 1 crore, it would have sent shivers down the spine of any management. What happens? Financial creditors less often go to NCLT. Operational creditors are often going to NCLT. Now, in such cases, they send such a strong signal to other people who are perhaps being threatened using this process. Usually what used to happen back in the day is that they file a civil case, and also they file a 420, 406, there's a breach of trust and cheating, etc. And then now, like how they say that arbitration has preceded civil courts. Now, insolvency proceedings have preceded arbitration. Now, what is very important for us to note here is this. Supreme Court very clearly says in Mobilo that one, NCLT cannot be used. Insolvency proceeding, adjudicating authority cannot make any findings on merit, and two, it cannot be used as a recovery form. That is very important. And also that this was also reiterated in Swiss Tribunals. Now, what is important, what is interesting in this case is that the issue of limitation. Now, the issue of limitation is this. Now, there is a clause that they have to run each taxi for 7,000 kilometers every month. And for that, they have to, and this issue of limitation comes in because they are claiming from September 15 onwards, and limitation issue has been addressed by the adjudicating authority, but not the appellate authority. There's an interesting case of Kothari Associates, where there's a distinction between continuous cause of action and successive cause of action. Now, every time 1 month ends, they have not used 7,000 kilometers, their cause of action actually arises. So it's actually very interesting to look forward to what the NCLAT decides on this.
Very interesting. We all will be looking forward to what happens on the next date. Ishna, your final comment before we end the show.
Yeah, so I think one of the biggest learnings I take in, as you said, that, there should be no misuse. I think there's a provision, section 65, which is one of the, I think, most powerful sections of the code, which allow that if, the proceedings that have been initiated are for a purpose other than for resolving the company, because, like we've discussed, the entire intent of the code is resolution. So here, like, in this case, there were so many email correspondences, which the creditor was aware of, which they did not, put forth. And also the addendums were not put forth. So I think section 65 is something I take as a big learning, where, where it's clear that it's being used for the purpose of only recovery. That can be used, and of course, especially in cases of public listed companies, because section 9s we've seen in all sorts of matters, be it Uttam Galva, be it Reliance Infrastructure. So considering all of those, I think wherever there is, as a lawyer, I mean, I see that 65 could be one of the applications one could consider.
Thank you so much, Advocate Ishna Kumar, Tahira Karanjawala, Advocate Shashank Garg, Advocate Sameer Jain, Advocate Shravan Shankar. Appreciate your sparing time and joining us on this very important issue. Lots of learnings from this episode. Because it was HCL Tech, it caught all the attention, I must say, but much on the right note. Thank you so much, viewers, for joining. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.